Good morning. I am Oreste Pollicino, and basically I'm speaking on behalf of the members of the Center on Digital Constitutionalism and Policy for the Friends DICOPO. Specifically Cornelia, Giovanni, Paolo, and Andrea, the founding members. Just 2 words, and then I will give the floor to Cornelia. That she wants you will take my place. Clearly, you are much better than me, also in moderating. And what I would like to say is basically 2 words, ciao Andrea, about DICOPO. I mean, maybe you could ask, what does it mean, digital constitutionalism? I don't have an answer now, and this is exactly my research question. But for sure, I think that you can understand which is the perspective. The perspective is to try to foster a debate. And today I'm so proud that we have so many great key players in the European policy making. It's the second time of the second event of DICOPO. The first one was with Vice President Vera Jourova in relation to all the topic that is not totally relevant, disinformation. And we are so happy that today we are more than the first time, and we will be more in the future. Basically, the idea is to start from the basic. The basics, what we call the digital fundamental rights. What does it mean? Basically, the fundamental rights that we know in our constitution, in the Charter of Fundamental Rights, the European Convention, in the digital context. So there is nothing new in terms of category. It's new the balancing, it's new the approach, and I think a public law perspective, not only public law, but the public law perspective complemented with the institutional perspective can really make an added value to a debate. This is our, let's say, our mission, or if you want, our wish. Having said this, it would be important, I think, to try to understand 2 main things. The first one, it's the classic question, but that I already got a few times. Who is going to finance this center? It's self-financed, self-funded, meaning that at the moment, exactly because we want to work on quality and not on financing, we are really trying to self-finance the project. It's important as an investment, but I think it's the best way to gain, let's say, a respect and quality. And then we will see. We will open clearly in a very fair way to founding. We are working on the one end with the Commission, clearly on the other end with the private sector, but always in a very transparent way. But not now. Now is a moment of a debate of the substance, okay? Second point, we are not alone. We have a research committee that honestly we are very proud of, because there are colleagues, academics that are basically focusing on 5 main areas: content, data, cyber, consumer, and AI. And I would like to mention them because they are friends and colleagues. They are working again without any, let's say, economic incentive, but with a research incentive. Sometimes it's much more important, the economic one. And they are producing really good stuff of work. I will invite you to read their work. It's on the website that you can look at it, www.dicopo.eu. It's Alexandra Kutterer, or something like this, for content. Mikolai, again, a very easy name, Varzenvits for data, Roxana Radu for cyber, Catalina Guanta, consumer, Giulia Gentile for AI. I'm sure that you know this person, and if you should not know, please read their scholarship. But now I think I spoke too much. It's the moment to start. And in order to start, the best person to call on the floor is Cornelia. Please, Cornelia.
Thanks, and hi everybody. So I have been very honored to be part of DICOPO. And so this is also the first time that we're doing this live event. There has been one back in last year. Now we have a little bit of a disappointment this morning. Axel Voss' office has called. He's sick. and can't come, and we all wish him the best, but we all don't want to have him here in the room today. So Giuseppe has kindly offered to do the keynote, and then we can actually do this in the proper way. So we have first the keynote and then a panel discussion, not as announced. And we also have Bertine Martens as an additional speaker for those who haven't seen the updated agenda. And I will announce Giuseppe now, and once after keynote, please come all speakers on the panel, and I will announce everybody else. So everybody obviously knows Giuseppe Abbamonte here. I have found an old Politico article titled "Abbamonte Moves Up" when he was announced director, and that he had already 20 years of experience by then. So that makes something over 30 years of experience within the commission. I couldn't believe that myself, but it seems to be counting right. He has a bit of experience in L&O in a law firm that we all also know. But what is amazing, Giuseppe has really worked on all digital files across the board, from consumer issues, cybersecurity, media, the code of practice on disinformation, the copyright fights and copyright directive, and with all of that, he's probably the most knowledgeable person in the room. I would please come up and tell us what's happening in that space.
Shall I go there?
Yes, you can go there.
Yes.
This is the place for the keynote.
Excellent. So, good afternoon, everybody. I am also, so I caught a cold, and I feel under the water. So if I were to say something inaccurate or silly, you put it down to the fact that I am sick. I followed the work on copyright and AI from the outset because I was heavily involved together with Emmanuel Duchalard who is now the new head of the copyright unit. So I was heavily involved in the negotiation of the copyright in the Digital Single Market Directive. And the directive contains two exceptions, so one on commercial TDM and the other one on scientific TDM, which are all compulsory for the member states to implement. One is also, so the one for scientific or for research TDM is also compulsory for the right holders. For the other one, so for commercial TDM, the right holders have they have an opt-out, so they have the possibility to reserve their right to TDM. And so the Article 4, which is the one regulating the commercial TDM, has become a real bone of contention because it is the provision which allows the policymakers, so the EU regulator, to balance out the two different interests at stake. So the interest of the right holders basically to get remunerated if they choose so, and by concluding a license, monetize their content, and the interest of the innovators basically to innovate, so to use the data in order to train the algorithm. So it may be assumed, and there is something which is not, it is not a trivial assumption because we've challenged right, left, and center, but it may be assumed that the exceptions, the TDM exceptions, cover all the activities related to protected works which are required for the training of the models, such as the extractions, reproductions, and compilations of the data sets, and of course also the ingestion of the data into the machine, into the model, into the algorithm. And the fact that the information extracted through TDM may be used to train algorithm and benefit from the TDM exceptions is corroborated by the AI Act, which addresses these issues in numerous places and which contains some transparency requirements aimed at bolstering the copyright provisions of the directive. Now, we have engaged, so the copyright directive was, the final text was agreed in 2019, so it was a few years before the artificial intelligence emerged and took the world basically by storm. And then we had to engage with a number of stakeholders to understand whether the exceptions work well in practice, in particular the Article 4 exception, and what are the challenges faced both by the right holders and the developers. And it is what I would like to talk about today. So everything I'm saying is the result of endless discussions and workshops that we had with the right holders. So the first challenge is that there is no generally recognized protocol for machine-readable opt-outs, no standard ways for expressing the reservation of rights for content which is not publicly available online. So for the content which is publicly available online, the opt-out must be expressed in machine-readable way. For content which is not publicly available online, the opt-out, the reservation of right, does not necessarily have to be expressed in machine-readable way. But basically, everybody goes its own ways. There is no generally recognized protocol. The other thing is that the protocol, so the ideal protocol, should allow right holders to express the opt-out across the internet and not just on the website of the distributor or the website, for example, of the right holders of the press publisher. The protocol should also allow right holders to express the opt-out in an unambiguous way, which can be understood by the machine crawling the data, and in a granular way. Because right holders, for example, may not want to opt out from TDM altogether, but just from machine learning for generative AI purposes. But for example, they may be perfectly all right with TDM for indexing and crawling works and websites for the purpose of providing a search engine. Another thing which is very important is that the protocols should ease the discovery by the developers of the models of the reservation rights and the licensing policies of the right holders. So there is something which is really, how can I say, of quintessential important if we want to create the framework conditions for a thriving licensing market and fair licensing market to emerge in Europe. So as I said before, we are now working on the effective implementation of the right reservations and the opt-out under Article 4. And we have observed in the course of all our talks a number of marked differences between creative sectors, so in terms of implementation of the opt-outs and the conclusion of the licensing agreements. So there are sectors which are much more advanced in terms, as I said before, of opt-out and conclusion of licensing agreements, monetization agreements, than other sectors. So we have delved into all the outstanding challenges linked to the reservation of rights under the TDM exceptions, and all stakeholders welcome the ongoing work. So to develop these opt-out protocols and acknowledged that different opt-out solutions could coexist, basically combining domain level as well as metadata level reservation. I remain to be convinced, but it is something that we are discussing. Something which is, so we have tried to gather input from the participants in all our workshops about the effective implementation of the rights reservation mechanism, including possible means to support the development of a licensing market for training data. And the participants agreed on the need to progress towards, and it is something which is really important, a common vocabulary on rights reservation, such as the common understanding of machine readability. Various participants also asked for more standardized solutions to be developed for the exercise of the opt-out. Many right holders expressed willingness to work towards effective licensing solutions, while it was generally acknowledged that few of such negotiations took place so far, in particular in certain industries. Do I have 5 more minutes? Couple more minutes. So shall I say then something maybe about, so what we are doing, an idea which was flaunted, which is very interesting, is the idea of a central registry with information on the reservations of rights, so a central registry or a portal, no, which would allow basically the developers to find out whether the works are available, so are maybe freely mined, or whether a license is required. And a feasibility study on the central registry is in preparation. And its scope comprises assessing existing solutions, as well as identifying the possible structure, functionalities, and costs of developing, operating, and maintain the registry or the registries. Few words about AI copyright, so the AI Act and the copyright-related part. So there are 2 key provisions in the AI Act concerning copyright. So there are the obligations on the providers of general-purpose AI models to put in place a policy to comply with the Union copyright law, and also to provide a sufficiently detailed public summary on the training of the data, so the training data which have been used. So there is something that will be carried out by the AI office. So the regulation is not in force yet, but basically this obligation will come into application 12 months after the entry into force of the regulation, which is expected in August this year, so which means that the first summaries should be published approximately, if everything goes fine, by August of next year. And the implementation of these obligations will be facilitated by the AI office, template, possible guidance, and the code of practice. I am very experienced with the code of practice, with code of practices in general. There are lots of people, Oreste is also very experienced. I don't know whether the conclusion of the code of practice there will require yet another honest broker. We shall see what we shall see. 2 words about the future, because there is something which is really interesting, I believe. So what is going to be the compass for us? So the first is what are going to be the objectives also for the new commission? The first thing is working on the emergence of a well-functioning licensing market, which may require a reflection on the development of fair and reasonable licensing terms. And there is something which is important for 2 reasons. The first reason is basically the remuneration of the right holders, which is very, very important. And the other reason is to exclude the risks of lockout of European innovators who may not afford, for example, a hefty, the hefty price of a license. The other issue, which we will not deal with today, is a reflection on the issue of the paternity, copyright status of the creation, and the distinction between AI-generated output and output generated by a human person with the assistance of AI. But I will pause here. Thank you very much for your attention. Spiritually and physically.
So if I have additional questions, I will just ask them directly. Okay.
With moderation.
Okay. So I will very quickly, so that we can advance and get into the discussion, present the rest of the speakers here. Everybody knows, obviously, Andrea. Andrea Renda is the head of SEPS since November 2023 appointed. Congratulations again. And also has a lot of other fellowships in addition to SEPS, and has been, I think, a leading voice in particular on the AI Act. Exactly. I will not read all the additional fellowships and work that you have been doing, but I think for this panel in particular, the incredible work you are doing on AI is what counts most, and we'll start with that. Then we have Cullen Miller, who is Vice President of Product at Spawning AI, and he brings the technical expertise to the table, and we already had a really interesting discussion, so I'm very happy that you can join us and explain a little bit the details behind those protocols and the tools that might exist or do exist that Giuseppe mentioned. And then we also do have Bertin Martens, who is a senior fellow at Bruegel, and he has been working on also a lot of digital economy issues, e-commerce, geo-blocking, in particular the digital copyright and media and other laws as a senior economist at the Joint Research Center before joining the Bruegel think tank, and has been there also in the commission and quite a career during commission and research center. He's also a research fellow at the Tilburg Law and Economics Center at the Tilburg University in the Netherlands. So we have a lot of expertise around this issue. I would like to start off with Andrea to go a little bit into the details of the AI Act. You've been following the trialogue. Can you give us a little bit of the background, how the copyright provisions entered into the AI Act and what they are supposed to mean in relation to the Copyright Directive?
Yes, let me see if I can, yeah. So first of all, thanks for the invitation. Thanks and congratulations for the creation of the COPO, both of you. And I mean, well, everybody that is involved, Andrea back there. I mean, it's a pleasure to see a new player in town coming up with an agenda that will certainly be very relevant going forward. So congratulations and good luck. I'm going to be supporting this in an advisory mode with a pleasure. Also, Oreste asked me to be part of a, how do you call it, scientific board or scientific? Well, yeah. So happy to be here, and hopefully here and many more events. I've been involved early on in the AI Act. Because I was a member of the high-level expert group on AI, the European Commission back in between 2018 and 2020. So the first thing that I want to say there is that implicitly there was something that we find now in the recitals of the AI Act that refers to the Copyright in the Digital Single Market Directive that was already back then referring to the need to preserve the delicate balances that are built in legislation, and so the trade-offs that are meant for specific purposes, also distributional in some cases, because we've seen the emergence of the digital ecosystem as something that very easily polarizes and concentrates power in the hands of happy few. The rights holders, just like many real economy players in other domains, are to some extent protected and taken care of by legislation at EU level to avoid that they end up losing their negotiating power. And this is what we call the centripetal forces of the internet. What I'm referring to is that when we wrote the ethics guidelines for trustworthy artificial intelligence back in April 2019, we already deviated from the original mandate that the Commission had given us, meaning talk about ethics and only ethics. We coined the term that today is very widespread, which is trustworthy AI, where trustworthy AI has three elements. Of course, it has a robustness. Today we talk about red teaming and all these things. It has the ethical alignment, but it has the legal compliance with existing legislation, not only because the EU legislation already carves in stone many of the provisions related to fundamental rights in particular, but also safety and many other aspects, but also because in legislation you have the political compromise where different players are and their stances, just like Giuseppe was saying in his introductory speech, in his keynote, these are interests that have to be composed politically and on the basis of evidence going forward. Of course, when I then later was asked by the Commission to lead the study of the impact assessment of the AI Act, which I did, the AI Act was like the pale image of what it is today. It was 2020, in the run-up to a presentation of a proposal in April 2021, nobody was talking about copyright. Text and data mining issues were being taken care of at the time, or it has just been taken care of through the copyright, the CDSM directive. and most of the attention was on fundamental rights and safety, so on trying to mitigate those risks through a risk-based approach. The real issue in copyright, of course, is in late 2022 when generative AI systems such as ChatGPT come in, and you have this idea of systems that can process an enormous amount of text, and they move from the classification age, if you wish, to the autoregressive mode, if you wish, right? When a sophisticated machine based on machine learning and statistical techniques, basically, starts being able to give very good answers by estimating I'm simplifying here, but in a statistical way, what is the right combination of words that is most likely to be a good answer to that combination of words that is given as a prompt, right? That means being able to access an enormous amount of data. And for ChatGPT, we're actually lucky because the original ChatGPT, so GPT 3.5, we actually know much more than the ironically called OpenAI today, because ironically called OpenAI, it's the closest company in the world. But the original GPT 3.5 has a lot of information on where the data comes from, what the number of parameters is, and so on and so forth. So we start learning that this very powerful systems take data from specific repositories such as Google Patent, Wikipedia, but also repositories such as Common Crawl that include a lot of thousands and thousands of websites from all over the world, mostly Western, not necessarily all representative, but of course it takes a lot of data that potentially is protected by copyright and reuses it on a constant basis to generate, well, in the case of ChatGPT, it was a finite set of information and data. Increasingly, it becomes a constant learning also from the internet. And that is, of course, a problem for those that produce content, because we are here not in a case of plagiarism, and then I'll wrap up so that you can continue the conversation, not a case of plagiarism or copying, but a case of use to generate new information that is not identical to the present, but that without that basis of creativity and content would not be possible. So the issue, and I'll close with an open question so that we can continue the debate, the issue here is what kind of balance could we strike between the production of content that is protected by copyright, that is supposed to remunerate human creativity, and the placing on the market of that creativity. So both the moral attribution of authorship, but also the commercial right of exploitation, which are the two inevitably complementary components of copyright. How do we reconcile this body of legislation that is there to reward creativity, human creativity, with a body of legislation, with a technological development that is there potentially to use that body of human creativity to develop a flow of machine-generated creativity, right? And that is a delicate balance. I anticipate some of the polemic that probably might emerge in this panel, also with some of the colleagues here, my co-panelists. Without one, there's no other. So if you only look at the flow and not at the stock, you might forget the fact that human creativity also needs to continue flowing for machine creativity to continue generating. And that is what I leave you with, ready to get in the next turn.
Thanks, Andrea. Yes, and we'll hold this thought because we are going to talk about this economic and fundamental rights balance that we have to draw in a second. And I want to go back a little bit to Giuseppe's point about the protocols and the opt-out mechanism, and go to Cullen, who is, as I said, the Vice President for Product of Spawning AI. And I think the best way to start that conversation is to explain a little bit what Spawning AI is and what type of tools you're providing.
Yeah, sure. Can you hear me? Yeah. Okay, great. So in 2022, so amidst the onset of the generative AI hype bubble, we developed a tool called HaveIBeenTrained.com, which allowed anyone on the internet to search and index and identify their works in the LION 5B training dataset. This was the very popular dataset that was put together by a German nonprofit named LION. We have since expanded that out to index many other public datasets where you can identify your work. Not only can you identify the work, but you can also add it to the Do Not Train registry. So we now have a registry that holds over 2.4 billion independent opt-out requests. We then took the core of Have I Been Trained and extended it out into a public API for model trainers to be able to honor these opt-out requests. We brokered a partnership with Hugging Face, who is also the largest host of public and private data sets online, and are a key piece of infrastructure in this ecosystem for developing and training models. And so what that means is our integration extends to all the data sets that are hosted on their site. So if I'm training a model and I download a data set from Hugging Face, which is where model trainers go to get data sets, unless they're crawling their own, which we'll get to in a moment, I get a list of do not train requests. So I can subtract that from my data set, pre-download, and train my model off of the data set with honoring the opt-out requests. So this has been a contribution of ours. We also have built some tools. What we're hoping for, it will develop into an open standard. Right now, we're talking to a lot of the large companies who are crawling for model training purposes and are building large web scale data sets. This is a smaller group of players. So this tool is called AI.text. It functions similarly to robots.txt, which is another way for rights holders and domain registrars to specify to web crawlers what can and cannot be trained. And the reason that we're strongly advising against a robots.txt, although I wouldn't suggest taking it down right now, but in the longer term, the reason that we want this as an independent file is because there's a lot of data that's already been crawled and that exists in data sets, and we don't think that checking at the time of crawling, when the data sets are being pulled together, is sufficient for the most effective and efficient way of honoring all of these opt-out requests. We think the critical time to check is, of course, at time of training. So we all know that all of our data is already in these web scale data sets. By checking at time of training against our do not train registry, will prevent training or prevent model trainers from training on this. And AI.text allows, via our API, the ability to check at the time of training. And so this also allows you to retroactively apply permissions to data that's already been crawled. And I think this is a very important distinction, and why I think robots.txt is insufficient. Yes, there's also market reasons too, for actual, just from the model training perspective. Yes, we have some other tools that extend into licensing markets, which we're just starting to put out into the world, because we see opt-out as the primitive and grounds for licensing beyond that. But I think for the sake of the conversation today, I'll pause there unless we want to get to that later.
Yeah, just maybe one clarification. So there's the data sets that have a lot of copy protected work in there, or data protected, personal data protected work, or potentially, and we talked about the CSAM. And then we have the training, so the data will be pulled from there. Can you make a little bit of distinction of the value chain and how you think through this?
Yeah, so I just want to seek a little bit of clarification on that. So, but sorry, do you mind just restating the question just a little bit?
Yeah, no, so who should be responsible for what you provide as a machine readable protocol?
Yes, I see. Well, ultimately we're building this for model trainers, so there's a lot of data out there, and just the tools for aggregating data don't currently have a way of knowing what is copyrighted material and what is not. So as data sets are just a wide net, and I mean there are things like robots which will narrow the scope of what's available, which is also perhaps a troubling trend. We're seeing the internet at this point is 20% less available and is more closed off because of some of this new research that's been done. So to answer your question, I think model trainers should be responsible for checking their data, but assuming good faith, which I definitely do, that there's not a good way for them to know, and I think this is again why the registry is the best solution that we can think of for just checking against this, and then you're compliant. So I think the onus is on the model trainer, if that answers your question directly.
Yeah. So and with that, and maybe it should also be said that the copyright directive has been adopted before Gen AI really was relevant. And with that, maybe a question to Bertin, who is studying the economic impact of copyrights law and wrote an article or a paper on the economic arguments in favor of reducing copyright protection for generative AI inputs. So basically, Bertin, in your mind, the current copyright laws then, do they have the right balance of fostering production innovation in the age of generative AI?
Thank you very much, Cornelia, for having me here. And also congratulations to the couple for this event. I make a distinction between copyright before and after the emergence of generative AI models. In the world before generative AI came into place, copyright was an issue that had to be settled within the media and cultural sector, between rights holders and users within that sector. After the emergence of generative AI models, copyright is an issue that spills over to the entire rest of the economy. And there are strong spillover effects because these AI models are being used virtually across every sector nowadays in the economy. And in that context, I think the balance is no longer right when you let a small part of the economy, the cultural media sector that represents, 3-4% of GDP, have an exclusive right over what's going to happen in the economy of the other 96% of the GDP. The door has already been opened a little bit, put ajar, during the TDM discussions on the copyright directive more than 10 years ago, 15 years ago. And they're opening up TDM for basically researchers, non-commercial researchers in Article 3 CDSM. Was an opening already because the spillover effects on research and innovation in the EU were acknowledged. And for that reason, and that was mainly a debate between researchers and scientific journal publishers. It didn't go much further than that. So these externalities have to be taken into account when we think about copyright. And I think a strict enforcement of the current situation, the pre-generative AI situation, in the current generative AI situation would not be an appropriate balance. Media producers, music, text, audio, visuals, material, and so on, benefit from AI models. They use them already on a regular basis in all their activities. So the best model, the better models are also better for them. It increases their productivity, it increases their ability to produce creative outputs, innovative outputs. If they are going to charge license fees to model developers, that will automatically mean a reduction in the amount of data available for model training, because model developers are not going to sign license deal with each and everybody in the universe on the internet or available online. They will limit that. And maybe for big companies, this will be possible to pay for these license fees. But for small AI startups, I'm afraid this is going to be prohibitively costly. So this will reduce the amount of innovation, the pace of innovation in my view. It will reduce the quality of AI models because the amount of data available will be reduced, and that will have negative efficiency effects on the entire rest of the economy. We were talking, of course, about the possibility for the spawning is a very good example of this, of making a tool available where copyright holders can declare their interests, and then a negotiation can ensue between the model trainer and the copyright holder over a license fee. And Giuseppe mentioned the possibility of fair, reasonable, and non-discriminatory licensing fees. And actually this FRAND concept is appearing everywhere in EU legislation nowadays, in data issues as well. This came over from the patent world, from standardization patents essentially, where we already see it creates a lot of problems. And there are numerous court cases pending there. It will become incredibly more difficult to settle that in a data world, and especially a data world for training of AI models. I don't exclude that if such a transparent market would emerge, that actually the marginal cost of the marginal price of these licensing would drop to close to zero, because there may be diminishing returns on the amount of data that you use for model training. And at some point, companies will say, well, we have enough, or we could maybe improve a little bit the efficiency of our model if we get these and these more data, but that improvement is small, so we pay a lower price for these and these. So you need fair, reasonable, market-based, and discriminatory pricing for your licensing if you want an efficient market to take place. The last point I wanted to make is that we should take into account that there are not only spillovers from the media sector to the rest of the economy, there are also international spillovers. The AI Act says model developers, model deployers should respect EU copyright law. But copyright is territorial law, only applies within the EU. It doesn't apply in Japan, in Singapore, in the US, or in the Gulf states, for example. We'll have to keep a close eye and monitoring what is going to happen, particularly in the US, where the fair use and transformative use doctrines are the subject of a number of pending court cases. We don't know yet how they will turn out. If, and that's still a big if, I admit, they would turn out in favor of transformative use and abolish the need to sign copyright agreements and pay license fees, then if Europe would go for this strict copyright regime, that would clearly diminish the competitiveness of AI companies based in the EU. Extraterritoriality of copyright applications would be a first, as far as I know, in copyright, but I'm not a lawyer, so lawyers may have solutions for that. But it's something that we should clearly take into account. We don't want to nip in the butt our AI startups in the EU in that respect. We have one ongoing court case already, well, in the UK actually, with Getty Images Against Stability AI, which is precisely about that. To what extent do you admit extraterritorial applications of copyright law? I stop here.
Thanks. That's a very strong view, and I think I will hand it back immediately to Andrea for a reaction. But I also wanted to say that we are trying to have Q&A. I see there are a couple of rights holders, organizations represented, so they should also step up, and if they disagree. But over to you.
They're waiting for the end of the panel discussion to just jump at the jugular of whoever said. Listen, I take this from, let's say, historical and academic and then more practical policy-oriented perspective. And historically speaking, I think we've had this conversation before, because copyright actually It's not just about the books or, or journal articles and stuff like this. Copyright also protects software, right? And there's been, as everybody knows, a long discussion as to whether computer-implemented inventions should also be protected by patents. Intellectual property and software have a long, very difficult history, but the fact that software is protected by copyright, and thereby is not just 3-4% of the economy. The discussion is already spread with the internet into the whole of the digital ecosystem. This is something that maybe can bring us back to the early days of the internet, and let's see what happens. Does anybody remember, or well, anybody, because there's a lot of younger people here, ever heard the name John Perry Barlow here? Yeah, remember this guy that said copyright is dead on the internet. Why? Because, of course, you have a gigantic machine that is a copying machine that is an end-to-end architecture where content gets spread in digital format. It can be replicated endlessly. Forget about the possibility of claiming compensation for something. And it's been a very complicated story, but I don't think copyright is dead, right? Since then, it's been complicated, but the lessons we have learned is that we have to think about how technological developments change the dynamics of the market, as you were saying, and also how different starting points in, which is a very law and economics approach, if you wish. I'm going to go to the academics part. How the starting point of a potential negotiation changes the balance of interest that emerges in the end. I'm happy to speculate a little bit on how we see this market developing going forward. But I see a lot of, certainly, a completely automated set of transactions, a set of, could be registries or platforms that facilitate the identification of what rules come with what content. It is a little bit what we saw many years ago with digital rights management, which is sort of a half revolution at some point, but it still remains ongoing. But anyway, the lines of code will determine the level of diffusion and access to training and not access to training that you can have with a specific content. Sorry for the post-lunch academic lecture in 3 minutes. From a pure law and economics perspective here, we are facing a shift in the allocation of usage rights, potentially. You can protect the original copyright with what we would call a property rule, which is the right to exclude others. And so a pure right to avoid that others use your content for training purpose, for example. And this is something that is typically efficient. If you go back, there is a famous, Oreste would know this, a famous article by Guido Calabresi and Douglas Malamud, Property Rules, Liability Rules, Inalienability, One View of the Cathedral. They say, depending on the level of transaction costs, a property rule could be the most appropriate rule or not. When transaction costs are very high, and there is a use in having access to the original resource, you might want to shift the protection of the property rule into a liability rule, which is a right of accessing the work and remunerating the work, which will go in the direction of Friend or any updated version of that tries to remunerate a little bit more, because Friend very often it's a very spiritual type of category. It's almost impossible to find a remuneration. We'll see now with the Data Act and with many other provisions that try to go into the fair remuneration that are very complicated. Now, in a situation like this, the market and the context determines whether it's better to have a right to exclude others. That is just the beginning of a potential negotiation. Then the content holders will need to set the price, and I get to back to this in a second, or whether the first choice is in the hands of the model trainers and the AI companies that then would have access. And a little bit like when we have expropriations or takings, they would need to remunerate a fair value. Okay, these are basically the perimeter of the analysis. I want to add 2 things in how we can solve this problem conceptually. First, the law and economics literature doesn't stop at simply saying statically, well, it's better to have a property or a liability rule to protect the property right. There is also a dynamic version of this. There's authors such as Lucian Bebchuk that have looked at this, and the issue is different when you look at this from the perspective of incentives. So what is the incentive to produce new content if you know that content that you are producing will be under a property rule or a liability rule? And you might be less incentivized to invest in the production of new content if you know that you're going to be under remunerated because you have a Friend licensing, or you have a zero price liability rule, like the one that more or less you're trying to explore, which is the right to take the content. So go 5-10 years down the road, you may see that the content industry doesn't produce content, And what I consider to be a positive externality of the content industry into AI rather than a negative externality because the content industry withdraws access to AI. I said, so it is a market failure because of free riding, if you wish. That would lead to an underproduction of content. It's the same thing, the people that have done telecoms, when we think about, do I invest in a new network knowing that I'm going to have to share it at regulated prices very low? Maybe I don't invest. This is the history of telecoms regulation in Europe is a little bit like that. And the same thing happens with copyright when you have this system of incentives. So that's one thing. The dynamic version, in my opinion, does not support the same conclusion that you reach in a more static analysis of what would happen today and maximizing the level of content. And the other thing is the balancing of interests. And in my opinion, we have seen in a variety of sectors, the basically, well, originally, authors such as Mariana Mazzucato call it the value capture, right? It could be the value capture from the automotive industry into services that are run on cars. It could be the value capture from the content industry into producing generated content by AI sectors. The whole of the agenda of the European Commission over the past years has been to sort of stop the value capture and reallocate and repatriate the value when the value comes with the content, the production, and the data. And this provision, in my opinion, tries to strike that balance. Final footnote. And this is a question for you, what do you think will be the way in which, what will be the incentives that will be generated in this market? And this is another bit that I think, maybe I'll write a paper on this in the future, but if I had to write a paper now, this is the other bit that, in my opinion, would be missing. It is the following. And the little hint that I give is, for example, the recent announcement by Google that their search engine might move into summaries, right? So as something more similar to GPT. Imagine a highly concentrated market where if your product and your content is not captured by the GPT or by whatever Google Gemini or something, it basically doesn't exist, okay? It's like not being listed on Google. We had a long competition case in which I saw the internal files at the early days of the 20 results of Google. 51% will click on the first link in the search engine, 0.7% on the seventh. So however you're featured in a repository of content like this makes a difference also in the diffusion of your content and what is made with it. I would expect, but this is more pure speculation of someone that does, sometimes I do foresight, so I'm trying to project myself into the future, that if the market for AI companies and the generative AI remains as it is, highly concentrated, and the market for production of content is somehow dependent on being featured and triggering generative AI solutions there, that the protection of content or of rights holders might turn into a form of competition when the rights holders might have to lower their price to be featured in those machine-generated content. So when this happens, the market basically reallocates resources in a way that weakens again the rights holders' position because there is a difference in the level of concentration in the markets. So things are dynamic. It's just a glimpse of one possible future. Maybe you completely disagree with this, and I take it because mine is a pure speculation. But just to tell you, the market has to be monitored. Giuseppe knows better than anybody else. And once you set and try to strike a balance, you have to see whether the market reacts to this. If it doesn't, then you have entrenched position of underproduction or inefficient allocation of resources, lack of not only allocative but also dynamic efficiency in the market, then you might want to tweak it and intervene. So I'll stop there.
Super interesting, and the challenge here is, of course, that both on the tooling side, on the Gen AI side itself, and the market, all developments are really open. No one really knows where this is all going. With this said, we have in the AI Act the Code of Practice for General Purpose AI, and I think it's very much modeled along the Code of Practice on disinformation. So a lot of people that are sitting in the room and know that experience can see clearly some analogies here. One support for the enforcement of copyrights is, of course, the transparency also vis-a-vis the copy-protected data in there. Now, we don't really know yet how this is all coming together, but rumors say there will be working groups that will deal with the code of practice. How could you contribute to this? And in particular, what is your business model as a company in this context?
Yeah, so right now, I think it's worth mentioning that we are pre-product market fit. We have all of the tools that I described earlier are not your traditional go-to-market strategy. It has definitely been, I would say it's resembled something that behaves more similarly to something like a public utility, that we don't want to exclude anyone from registering, and ultimately we think the registry should probably be handled by a public authority. We are not looking to squeeze rights holders to remove their data from data sets. That's not the business that we are in. That being said, operating as an intermediary between the rights holders and the model trainers, we do see a potential commercial service for model training companies to access the aggregation layer that we're pulling together. And it's worth mentioning that there's a proliferation of standards out there, and we are aggregating all of those because no one has the specific, in the absence of a standard, everyone's scrambling to try to get this in place. So our commercial service is for the model trainers. We're ultimately building data governance tools that will also include other services beyond the purview of copyright and Article 4. So that is the primitive with which we're operating on. We would have liked to build what we're building now first, but we see if you're going to build a data set from first principles, there's certain knowns that you need to define, and I think the first thing that you need to know is what can't be in this data set. So the subtraction process was a very unfun process to build and not very creative. We're really excited about AI, and we think the licensing market is the next step now that we have the ability to define what can't be trained on. And so we're building a product right now called Source Plus, where right now we have collated over 40 million public domain and CC0 licensed images. We're currently building another fully public open data set that we're building the ability to build sub-data sets of that, to fine-tune models, and so there's a commercial application there for people who want to use that. But the real goal is ultimately to offer models as a service. The licensing market it's unclear how this will function, because, and I think this is a conversation that hasn't really been had, I think, because the model trainers and the rights holders have asymmetric objectives and are kind of talking past each other. Obviously, we're trying to operate as an intermediary there, but in terms of the licensing market, the pricing per token versus the royalty model is something that I think needs to be surfaced. It's a difficult conversation to have, but this is something that I'm discovering as I'm doing user research, that the royalty remunerations are multiple orders of magnitude higher than what the model training companies are valuing that. So that's one reason why we're pushing beyond that, and the method of enclosure of value we think ultimately will be a model. There's more guarantees. There's definitely problems with that, but ultimately models as a service is really where we're hoping to be by the end of year, where you're licensing a model instead of the data set, and the models themselves are obviously trained on exclusive data. So if you want access to the data, you're going to access it by proxy of the model. Untested, we'll be launching this in Q4 ideally, but yeah, we're experimenting with that. But in the interim, we are still pressing forward with the licensing markets to test some of these assumptions to see if the valuations can match the expectations for the licensees.
Thanks. Unfortunately, I had a couple of questions regarding the openness and the closeness of models, but I don't think we really have the time now. But what I would like to ask Giuseppe maybe at the end, before we have one or two questions from the audience as well, is how do you actually combine the processes that you have started now with the opt-out mechanisms in your directorate with the AI Office, Transparency and Code of Practice and Disinformation and the template? Is there a combined work? Can you tell us a little bit more about the timeline, about the Code of Practice, or is that...
We need an extra microphone if you guys have it in the back. Yeah, because otherwise you have to go back.
Or I can
Sorry, could
Or you
use
come and sit with
the
us.
microphone
Exactly.
just for the video?
Yeah.
And then I will not do closings because
Yes.
it would be rather questions from the audience.
So
You didn't have the second. You didn't have the second round.
So, you answered the second question in your first one.
But he might want to react to me.
Let's go ahead. I'm really sorry.
No problem. Just a quick reaction to what Andrea said. I fully agree with Andrea, by the way. Copyright is a balance between static considerations and dynamic market considerations. But that balance changes when the production technology changes for these copyright protected materials. And with AI, we see a clear drop in the marginal cost of production of copyright, of media content, let's say. We'll soon face a situation where we, at home with our laptops, will be able to produce our own movies in which we perform, and our friends and family, and we can write a scenario, and you push the button, and within a few seconds you will have that movie. Is that a copyright protected movie? Maybe so. But we already see what's happening in the US with the Copyright Registration Office that says we are willing to register prompt sets that are fed into these AI models, but not the output of those models, because it's not produced by a human but by a machine. As an economist, I would argue there's no need for that copyright protection for that output. For the prompt set, yes, but not for the output, because the marginal cost of production is almost zero. So you don't need much of an incentive to produce that output. And that brings me back to Andrea's argument. Do we run the risk that if we take this opt-out option away in CDSM Article 4, that there will be less production in the media sector? I don't think so. I think the media sector already benefits a lot from these AI models because it reduces their production cost, and they're producing much more than ever before. And so I don't think there's going to be a negative supply response. That's all I have to say.
Thanks, Tim, and sorry for that.
you are a brave man. For much less than that, I got my car vandalized in the parking lot.
I've been through the text and data mining experience. I needed to put on a bulletproof vest sometimes.
So if you allow a sort of biblical...
Does it work, Giuseppe?
I don't know, but I have a baritone voice. So if you allow this biblical... Can you hear me? Yes. The biblical metaphors, I think it is easier for a camel to pass through the eye of a needle than for the TDM exceptions to be written off. So for us, the TDM exceptions are very, very important. So I am personally very attached to them. So are sacrosanct, and I believe that in Europe we have a situation which is, in terms of legal certainty, much better than in the US, because we have a framework which is very complicated, but the complexity of the framework reflects the complexity of the matter and the fact that you have different interests at stake. So there is one thing which is important. Now, the answer to your question, so everything comes together in the sense that the AI Act is not a copyright law, but it contains a number of copyright-relevant provisions which will underpin the TDM exceptions. Basically. There are certain challenges which I have tried to illustrate before as clearly as I could. Right now we will have to basically to tackle the challenges, and we will have to see what happens in the yes. So you
I'm already looking at.
So everything comes together, and on the timing, you know, you asked me a little bit of crystal ball questions because the AI Act is not in force yet. So if the AI Act gets published in August, no, it will come into the provisions will come. The copyright relevant provisions will come into effect 12 months afterwards. The code, no, not the code. Yes, the code will have to be adopted. Say but everything rests on a number of ifs. No, by May, and in a sort of ideal world, the templates and the guidelines will have to be adopted before. But again, take it with a big pinch of salt, because I don't know, nothing is in force yet.
Okay, I saw already 3 hands. I'm not sure we can actually take all, so I saw Elizabeth first,
So that's the wireless mic. You're gonna do
Luca,
that.
and then Anna.
Do we need a mic? Do we need one?
There is a mic. Like I said, I don't know if you have people.
Shall I just-
I don't know.
It might, okay, well, maybe I'll start. So Elizabeth Krosek from RELX, thank you very much. Interesting, challenging. A comment and a question. My comment being that actually content, quality content, is important for the future, not just for now. And I don't see it as content versus innovation. It's the foundation of innovation. You don't have it without. If you did, we wouldn't be having this discussion. So I think it's crucial, and I think it's also crucial that we, as Europeans, shouldn't be benefiting business models that appropriate content and then use that content, and then we give them the benefit of them being able to do that. And let me give an example, because we ourselves, so you will perhaps know us as Elsevier, so academic content, but we're also LexisNexis. Over the years, Nexus, it's an aggregator of news and all sorts of content, and we've always, our business model has been a mix of licensing and of scraping. As the law changed and became clearer, we have moved from scraping, because it was not appropriate to be doing, to licensing. We are compared to the big platforms, and may I say the startups that might be small in people but large in funding. We spend, it's our biggest expenditure, we spend millions on licensing, and those media outlets that don't want licensing, we don't carry. It's a business model. We've had to adapt. We've managed to adapt, and it works for us. We're nowhere near the size of the big platforms. But a question, actually, maybe to you, Giuseppe, and I was very interested about the registry that you're working on. We have a certain suspicion about central registries. Didn't work in the US, but somebody mentioned crawlers. And one thing that would be interesting for us on the content side and on the crawling side is to have a registry of crawlers, that there is a recognition and a separation of the different types of crawlers, and that it is very clear who does what, and there's an opportunity for the Commission to do that. We'd be very interested in that. Just wondered if you had thoughts on that.
Yeah, that's Luca. And please, can you
Thank you. Yeah, I'll be short. Thank you. Luca Bertuzzi, MLEX. For Mr. Abbamonte, I would like to hear a reaction about the territoriality question, because I think that is probably the blind spot of copyright law at the moment. So if you do put in place this licensing system, how exactly are you planning to enforce it outside Europe, or how do you envisage other jurisdictions will affect this system? And do you think that copyright rules as they stand now are adequate for generative AI, or are you reflecting on updating these rules? Thank you.
And the last question here.
Can I go? Oh, thank you. So Anna, oh, thank you. Hi. Thank you so much. This has been really, really inspiring. Anna, Public Policy, Amazon Web Services. Just one question / comment to Professor Renda, because you're making the exercise into looking into the future. If we were not to think about just licensing, but what to think about levies, and we know that CMOs are already very interested in putting that, could we take, like, for example, what we've done, the model for music, how many times our music is playing on a radio station, and then based on that, there's a royalties pool, and then based on that. I just wanted if you could give us, like, just because we know that CMOs like GEMA, SACEM, and also not only music, but everywhere are also putting their plans together on what to do with it. Thank you.
Very short answers, if possible.
Okay, also on the... So, we are not working on a registry. There is an idea. It is an idea which came out of the discussions. Is an interesting idea. I don't know whether it would be a registry, a portal, a set of databases, but basically is an idea which has merit. Elizabeth, I invite you to write to me write me a paper on this idea of registry of callers, and I will meet with you. So this is the first question. The second questions are a bit complicated. So it is true that copyright is territorial in nature, but the provisions of the AI Act are designed as a market entry requirement. So regardless of the place where the training is carried out. So basically, if you're not able to show that you abide basically by EU copyright rules, you will not be able to place on the market your applications, your models, and the like. And there is a very, in my opinion, clever anti-circumvention. Would you ask me another question then? Which one, if we need, I don't know yet. It's a little bit too early to say, because now we are really reflecting, and we have to be very careful for all the reasons which were discussed today. Thank you.
So Andrea, and then I would like to invite Giovanni and Paolo just to close up the session. But you go first. Future.
Yeah, the extraterritoriality, I think I agree with Giuseppe on this, is a market entry requirement, so I would subscribe to this view. It is an idea of, we're talking to the provider of general purpose AI systems. The providers are linked to the placing on the market or the putting into service of the AI system in the territory of the European Union, and so this basically a provision that avoids potential arbitrage in training systems outside of the EU, to then have a cost advantage when they enter the single market compared to the ones that have been trained in the EU that would have had greater restrictions on levies. This is indeed what I called the liability rule before. I was willing to go even back in time before jukeboxes or before others to piano rolls. There's a lot of literature on piano rolls, you know, those rolls that would contain songs so the piano will play by itself. This is the first application of levies that I know of in the history of intellectual property, at least from my scholarly studies. It is potentially a model because it eliminates the transaction costs, but of course it creates governance requirements and the monitoring of the market and the collection of the revenues.
Great. So Giovanni and Paolo. So thank you all panelists a lot. Please applause. Very there is never a dull moment in IP. I have the pleasure to see Lawrence Lessig next week speaking on Gen AI. So this is full circle in a certain way. Giovanni, Paolo, will you come up or will you stand there?
I mean, we can also.
Sit down.
Yeah, please.
Thank you so much, everyone.
No, but by
Thanks,
the way,
Cornelia.
So just to say a couple of words before to close the session of today. Of course, it's obvious to say, but I will leave it to Paolo to say. Thank you, of course, to all of you to come here. Just to say that we have different kind of things from Giuseppe, from the keynote, then from the panel, and all the things actually are showing that there are very different interests that sometimes, of course, are not overlapping to each other as it normally to be. And this requires a lot of coordination, a lot of conversation, and increasingly we are still, I mean, copyright law at the end has been, the realm of also hard law, because copyright has always been something very much related to the law, but it's very much increasingly becoming the realm of guidelines, the realm of code of conduct, precisely because the technological dimension is becoming quite relevant and requires like putting together different voices that do not necessarily share the same goals. So what actually it's interesting to understand from all this presentation is that the challenges that we have with copyright and Gen AI will probably lead to have like more collaboration among the stakeholders, even with different, even with different objectives. And this will require up to a certain point to find some ways to, and also to make closer different interests at stake in this case. And so that's actually is also one of the objectives actually of this project that we launched also with this second event, let's say, and it's exactly to have a platform also to, like also facilitate this type of conversations, this type of collaboration is exactly, one of the objectives. That is also nice, for instance, just mentioning like Andrea that was also thinking about the academic side of the thing, that is precisely one of the core of this project. But, I spoke too much and I will leave it to Paolo to properly close actually the event.
1 minute, just 1 minute because we are going to be kicked out. So very much happy to see the interest in this book. Personally, I found the discussion extremely interesting. I have now much more questions than I had in my mind when I came in, which is a very good sign. And I hope that there will be, and I think we should really think about giving some thought for future follow-ups. We didn't exhaust the topic, of course, far from that. And there are new things that will come up in the next months. So AI will remain high in our radar screen for sure. There will be other topics I think that would be worthwhile following as DCOPO in the future. One underlying and actually horizontal issue that may have some more light in the next future, it is the the recurring question about how to access the platform's data in order to have a better overview and to ensure a better oversight that cut across many areas, from AI to DSA to DMA and so on and so forth. So it would be a very interesting point to make once the adopted. There are other issues that are also coming up very soon, like for instance the conversion of the code of press and disinformation into code of conduct and the relationship with the DSA, and the list could be extremely long. I think we have a full plate in our hands to now to serve to you and to other friends that will be interested to join us for future events. For the moment, just thank you and hope to see you soon again. Thank you.